Hi there, my name is Katie Dwight, and I'm a staff attorney at Swords to Plowshares. And I'm going to be running this webinar with Becca Von Baren, who's also a staff attorney at Swords to Plowshares. And what we're going to do today is we have a little presentation for you, PowerPoint presentation that will take about an hour, or maybe a little less. And we picked out some issues that we thought were maybe a little tricky or confusing or particularly important. And we're going to review those during the first hour. And then for the last half hour or so, we would love to hear your questions or comments. The questions could relate to the presentation today or to anything that you're working on in your offices. Also, any questions about the on-the-job training program. So Becca's going to start us out, and I'll turn it over to her.
Hi, I'm Becca, and I'm going to start out by talking about continuity of symptomatology. So here's the big lengthy section from the Code of Federal Regulations, section 3.303B on continuity of symptomatology. So what I'm going to do is break this down so it's digestible. So what is continuity of symptomatology of a chronic disease in a nutshell? So this is a way of establishing service connection for diseases and conditions that are listed as chronic in section 3.309A, but aren't able to receive the presumption of service connection granted by 3.309A because they were not clearly diagnosed in service or within the presumptive period. Rather, symptoms of the condition were only noted during service or within the presumptive period. So some examples of chronic diseases, these are just a few of what are listed in 3.309A, but just to give some examples: anemia, arthritis, cirrhosis of the liver, diabetes mellitus, epilepsies, Hodgkin's disease, leukemia, psychoses, and active tuberculosis. So in 3.309A, each of these, some must be diagnosed in service and some have lengthier period of time. With psychoses, they can appear within a year of time after service and are presumptively considered to be service-connected if they are diagnosed within that period of time and the claim is made at any time later. So what we're talking about with continuity of symptomatology is a little different. The basic elements are when symptoms and signs of one of those chronic diseases are noted while the service member is in service or within the presumptive period under 3.307, and you have a showing of continuity of these same symptoms from the time they started in service or during the presumptive period to the time a clear diagnosis of a chronic condition under 3.309A is made. Now this is really important to remember. It can be shown, the symptoms can be shown by lay evidence or medical records. So it seems pretty clear and like two pretty easy steps, but following a CABC case called Savage v. Gober, unless a layperson can competently observe the relationship between the present disability and the continuity of symptomatology, a medical evidence is necessary to demonstrate a nexus between the two. Now, this means that unless a layperson can look at the symptoms over time and competently recognize them as proof of a chronic disease, a medical nexus statement is required to connect the current disability and the post-service symptomatology. So, for example, if a veteran could show evidence that she had pain in her left hand during service and can also show that she continuously experienced pain in her left hand from service until the present, and was recently, now this is 10 years post-service, diagnosed with arthritis, which is a chronic disability listed in 3.309A, in her left hand, a layperson's evidence is not sufficient to prove that the continuous pain in her left hand has in fact been a continuous symptom of arthritis and not a symptom of some other condition in her left hand. So she would need a nexus statement from a medical clinician to establish the link between the pain she's been experiencing in her hand and the current diagnosis of arthritis. So now the full requirements for continuity of symptomatology to show service connection is a current diagnosis of a chronic disability, evidence that symptoms of the condition were noted during service or during a presumptive period, evidence of continuity of symptomatology, and a medical nexus statement is likely required. So next I'm going to talk about the bilateral factor. Now this can be another confusing thing or something that a lot of folks don't know about. Now this is at 38 C.F.R. section 4.26. Now first, what is the bilateral factor? It's when a compensable disability exists in both arms, both legs, or paired skeletal muscles. The ratings for the disabilities of the right and left sides will be combined as usual, and then 10% of this value will be added, not combined, before proceeding with further combinations or converting to a degree of disability. So the bilateral factor gives veterans with disabilities that affect both sides of the body a higher total rating than veterans who are disabled on one side only. And to note, the use of the terms arms and legs is not meant to distinguish between, you have to have it in your forearm and forearm or hand in hand. It refers to the entire upper extremity as a whole and the entire lower extremity as a whole. So you could have a condition in your shoulder and in your right shoulder and in your left hand, and that would still be considered having bilateral conditions. Now the only time the bilateral factor does not apply to when a veteran has a condition on the right side and on the left side is with tinnitus or tinnitus. The highest rating for that condition is 10%, and no bilateral factor will be added. So now it gets to the math. So you combine the ratings for the disabilities of the right and the left sides as usual. Then add 10% of this value before proceeding with anything else. The rating for the bilateral disabilities and the 10% bilateral factor will be treated as one disability for the purpose of arranging the order of severity of and for all other further combinations. So it's helpful to think, to take a look at this using an example. So if a veteran has a left wrist condition that's rated at 30% disabling, and then they have a right shoulder condition rated at 10% disabling, and diabetes rated at 10% disabling, then the veteran qualifies for the bilateral condition for her arms because both upper extremities have compensable conditions. So the percentages of disability for the wrist and shoulder should be combined under the rating table. So that's 30% and 10%, making a combined rating of 37. Then the bilateral factor is applied. So 10% of 37 should be added to 37, making a new combined rating of 41. The rating of 41 should be combined with the 10% rating for diabetes, making a total rating of 47, which is then rounded to 50. So the veteran's total rating is 50%. Now, if the bilateral factor were not taken into account, the total rating for this veteran would be 40%. So that's how the math works out when you have an example using the bilateral factor. So it's a little tricky, but it's important to take into account because it does add that extra bump up for veterans who do have conditions on the right and the left sides of their body. The next we're going to talk about some special rules for combat injuries. So this is at section 3.304D. So if a veteran has injuries or diseases that were sustained in combat, it's very hard to corroborate these injuries or diseases because service members rarely see medics during combat, and when they do, record keeping is sparse, or the records don't get carried over into the veteran's service jacket later. There's a lot of reasons why the records might not exist. So the VA created there's special regulations for injuries that were sustained during combat. So satisfactory lay or other evidence that an injury or disease was incurred or aggravated in combat will be accepted as sufficient proof of service connection if the evidence is consistent with the circumstances, conditions, or hardships of such service, even though there is no official record of such incurrence or aggravation. So the second part is quite simple, just meaning if there's an injury that's way out of line with something you would receive in combat, then that won't be service connected. But at the same time, that's also an easy hurdle for conditions like TBI or injuries to joints or things like that. That if you're looking at somebody's actual duties in combat, it can be very easy to show that the injury is consistent with the circumstances, conditions, or hardships of their service. And the lay or other evidence, you can have a buddy statement of somebody who saw the injury. You can have photographs. Oftentimes, folks took photographs during service, and maybe you had a leg in a cast or things like that. Emails home, phone calls home, things like that, and sometimes a veteran's own statement will suffice. So then special rules for PTSD during wartime. And these rules only apply to PTSD which is claimed to have resulted from service in the period of war on or after January 1st, 1947. So if there's a couple of these. So this is from section 3.304 F1. Now, if there's evidence that a diagnosis of PTSD was made during service and the claimed stressor is related to that service, in the absence of clear and convincing evidence to the contrary, and provided that the claimed stressor is consistent with the circumstances, conditions, or hardships of the veteran's service, the veteran's lay testimony alone may establish the occurrence of the claimed in-service stressor. So for veterans who have a diagnosis of PTSD during stressor, the veteran's lay testimony may establish that the claimed in-service stressor occurred. And it's also important to remember that there's a case that came out of NVLSP, a class action lawsuit, that if you have PTSD diagnosed in service, the lowest percentage rating that you can be awarded for that PTSD is 50%. So those that's definitely something to keep in mind when you're when the veteran that you're assisting has a diagnosis of PTSD made during service. Now in F2, if the evidence establishes that the veteran engaged in combat with the enemy and the claimed stressor is related to that combat, and the absence of clear and convincing evidence to the contrary, and provided that the claimed stressor is consistent with the circumstances, conditions, or hardships of the veteran's service, the veteran's lay testimony alone may establish the occurrence of the in-service stressor. So the question here is, how do I show that a veteran engaged in combat with the enemy? Now, a lot of times that'll be evident from a veteran's DD-214, and it's not difficult to show this. From the M21-1MR, you can see all the different things that might show up on a DD-214 that'll confirm for the VA that the veteran was in combat with the enemy. And then if one of these does not show up on the DD-214, the VA will go through the standard process that they use to verify combat. Now, one thing that people sometimes get confused about is if you read on a veteran's DD-214 that they received a Global War on Terrorism Expeditionary Medal, a Global War on Terrorism Service Medal, an Afghanistan Campaign Medal, or an Iraq Campaign Medal, those do not suffice to prove combat, that the veteran engaged in combat with the enemy. So oftentimes a lot of advocates will see that and think it's sufficient to show combat, but unfortunately that isn't sufficient. But this list isn't, it doesn't mean that the veteran did not engage in combat if one of these things does not show up on their DD-214. These are just the easiest way for the VA to sort of presume that the veteran did engage in combat. Here's another rule, and this is from F3, and this is one that is used very commonly. If a stressor is related to fear of hostile military or terrorist activity, and a VA psychiatrist or psychologist, or a psychiatrist or psychologist with whom the VA has contracted, confirms that the claim stressor is adequate to support a diagnosis of PTSD, and the veteran's symptoms are related to the claim stressor in the absence of clear and convincing evidence to the contrary, and provided the claim stressor is consistent with the places, types, and circumstances of the veteran's service, the veteran's lay testimony alone may establish the occurrence of the claimed in-service stressor. So there's kind of a lot there. First of all, let's look at how is fear of hostile military and terrorist activity defined. Now, it means that a veteran experienced, witnessed, or was confronted with an event or circumstance that involved actual or threatened death or serious injury, or a threat to the physical integrity of the veteran or others, such as from an actual or potential improvised explosive device, vehicle-embedded explosive device, incoming artillery, rocket or mortar fire, grenade, small arms fire, including suspected sniper fire or attack upon friendly military aircraft, and the veteran's response to the event or circumstance involved a psychological or psychophysiological state of fear, helplessness, or horror. Now, in a lot of claims, it actually suffices to just state in the stressor statement that the veteran had a fear of hostile military or terrorist activity. And it's often not needed for you to go into what, in fact, the veteran was, what the veteran feared. It's best practice to write more, have the veteran say they heard mortar, incoming artillery, or they feared for potential IEDs, they heard mortar fire, and feared, had a fear of hostile military activity because of that. But it usually does suffice to just state that they had a fear of hostile military or terrorist activity. And then they have to get over having a VA psychiatrist or psychologist, etc., confirm that the claim stressor is adequate to support a diagnosis of PTSD, and that the veteran's symptoms are related to the claim stressor. Now this, it sounds like a big hurdle, but having the VA psychiatrist or psychologist with whom the VA has contracted confirm that the claim stressor is adequate to support a diagnosis of PTSD can happen during the compensation and pension exam. So that's not something that you have to have up front. You don't have to show proof of that. So you can have the veteran's lay testimony alone establishing the occurrence of the claim stressor, and the claim stressor can be related to the fear of hostile military or terrorist activity, and that will suffice. And now Katie's going to talk to us about VA proposals to reduce a rating.
Hi there, this is Katie Dwight. So I picked out a few issues to discuss, and they are VA proposals to reduce ratings, the VA duty to provide a medical examination, hepatitis C is a disability, and some issues related to effective dates. So when the VA proposes to reduce a rating, it must follow some basic rules. It can't just go ahead and reduce the rating. First, it has to provide due process, which I'll talk about in a minute. But then there's sort of levels of protection. If the disability has been in place for 5 years or 20 years, or if it's 100% total disability, there are specific rules for each one about when what factors the VA has to meet to prove that it should be reduced. So the first one I'll start with is the unprotected cases, which even unprotected ones have some protections from reduction. The VA must be based upon review of the entire history, and there must be an actual change, not just a change in the thoroughness of the exam. Any improvement must be in the ability to function under the ordinary conditions of work. And the VA must cite the evidence upon which the reduction is based. So if you have a veteran come see you who had been service-connected for less than 5 years, and the VA reduced their rating, there's a number of ways that you can try to help them by writing a statement up in support of the veteran. You can say that the VA did not review the entire history. If it seems like that's the case, maybe they only were looking at some very recent records and failed to look at the entire, take into account the entire history. And there must be you can say that there wasn't actually a change. Maybe the VA is just focusing on specific exams, or the current exam is more thorough than the last exam, and so it seems like there was a change, but actually when you look at it, they're really the same. And if the VA didn't cite all the evidence, that's against their regulations, and they need to do so, and you can ask them to do so. And that's just some of the ways that you can try to advocate for the veteran there. With the 5-year rule, there has to be sustained improvement before the VA can reduce the rating. And that means that it's not temporary or episodic improvement. And all the evidence of record, once again, must support the reduction. And that includes not just the C&P exam, but the entire medical record. And the C&P exam must be full and complete. It cannot be less thorough than the exam on which the original rating was based. So here you could argue that the improvement was just temporary, or that not all the records support a reduction, or that the C&P was not thorough enough. And then going to the 20-year rule, in that case, if the condition has been rated at or above a certain rating percentage for 20 years or more, the VA cannot reduce except in the case of fraud. So that's a really strong protection. It's going to be very unusual for the VA to prove fraud. What it means is that if you have a veteran who was, say, rated 30%, and over the course of 20 years, the rating went up to 100%. But the 30%, the start of the first rating at 30%, that is the only one that's had 20 years pass. So basically, the veteran is protected at the 30% rating level. And as time passes, he or she will be protected at the greater ratings. And this also applies when you can count the years when a rating is a result of a clear and unmistakable error, Q, and there's a retroactive increase. So if a veteran challenges a claim rating from 10 years ago based on clear and unmistakable error and wins that claim and gets a retroactive increase of 10 years, then those 10 years count towards the 20-year period of time. Those who are rated at 100% total disability also have some protections. The VA may reduce if there is clear error in the original decision. If that's not the case, then there must be material improvement. And material there means pertinent to the rating. So the VA must compare evidence available at the time of the previous rating to the current evidence. It may look at medical and lay evidence. And in order to help a veteran in this case, you might want to argue that if you see that there is some improvement, you might try to argue, well, it's some improvement, but it's not material improvement, or the improvement doesn't affect the veteran's functioning, so that means that it's not material. In a case where the VA plans to reduce a 100% rating, but the veteran is unable to maintain substantially gainful employment due to their disability, the veteran must be awarded a total rating based on TDIU. And reducing TDIU requires clear and convincing evidence that the vet is actually employable. So the burden there sort of is on the VA to prove the vet is actually employable. Another thing that has to do with reduction of ratings is when there's a change in regulation. The VA should not reduce a rating based on a new regulation. The VA must continue to apply the old criteria if the new criteria would result in a reduction. If an improvement in a disability warrants a reduction under the old criteria, the new rating criteria should be applied even when that would result in a greater reduction in rating. So, for instance, if you have a vet with TBI, they changed the regulation for TBI a few years ago. If this person was rated before that with the old criteria, and when the new criteria come in, the VA cannot now say, oh, you don't meet these criteria, we're going to reduce you. They have to look first at the old criteria. Then if it turns out that the vet would be, that the rating should be reduced under the old criteria, then the VA applies the new rating criteria and apply that even if it's less favorable than the old criteria. So that's a little bit strange, I think. And then as far as due process, the VA is required to provide notice to a veteran before reducing the rating. They provide 60-day notice before the veteran to respond. The veteran has 60 days to submit evidence showing that the rating should not be reduced. And also the VA has 30 days to request a hearing. And it would be good in most cases to request a hearing because that's going to delay any reduction that occurs. After 60 days, if the veteran had not submitted any evidence, the VA will make a proposed decision of reducing the rating, but they will again provide notice, another notice for 60 days to the veteran, and they will not yet reduce the rating for another 60 days. And if the hearing hasn't happened, they won't make any decision until that's completed. But so we basically get 2 periods of 60-day notice, and then finally after the second one, the rating is reduced on the first day of the month following the 60th day. So this is fairly straightforward, but I thought I'd review it. When does the VA have a duty to provide a medical examination? Well, all 4 of these items listed here must be true. So there must be competent evidence of a current disability or persistent symptoms of disability. That can be in the form of medical evidence or lay evidence in certain circumstances. If all the veteran has is his own statement that he has a current disability, or she, then a detailed statement. They must write a detailed statement, and you can help them with that. It should provide exact detail about the symptoms, how long they've been going on, when they occur, everything to do with the disability, and that may suffice as lay evidence to get the VA's, to trigger the VA's duty. But there must also be evidence establishing that an injury occurred in service, an indication that the present disability is associated with the veteran's service or with another service-connected disability, and there must be insufficient competent medical evidence on file for the VA to make a decision without an examination. It's rare that the VA will ever make a decision without their own CMP exam or say a DBQ from a private examiner. So in most cases, if there's evidence of current disability, evidence of in-service disability, and evidence of an association between the two or a nexus between the two, then the VA must provide the veteran with a medical examination. And this is crucial for a lot of veterans who can't afford to go to private doctors. Okay, I'm going to talk a little bit about hepatitis C, and the reason that I chose hepatitis C is that studies have shown that as many as 8 to 9% of veterans appearing at VA medical centers have hepatitis C. Some VA medical centers had 10 to 20% of patients with hepatitis C. And the highest rate of hepatitis C is found in the Vietnam-era veterans. In a Palo Alto study, 81% of patients had a history of intravenous drug use. 81%. And 11% had no identified risk factor. 3% had a history of transfusion, and 2% had both transfusion history and intravenous drug use. In Vietnam, heroin use increased steadily from 1970 to 1971 to the point where 10 to 15% of servicemen had used heroin. Although some people, it's surprising to some people that most of that heroin use was via being smoked rather than intravenously. 90 to 95% who used heroin in the Vietnam War in Vietnam smoked it rather than injected it. Still, intravenous drug use is a huge factor in hepatitis C, particularly among Vietnam veterans. And there's also, during combat, there can be exchange of blood through a variety of mechanisms, from handling someone who's injured to sharing a razor or sharing a toothbrush. So what the VA will do is look at the risk factors, which I've listed here. The testimony of the veteran may be sufficient to establish the occurrence of an in-service risk factor. But intravenous drug use after service will be hard to overcome. If someone if there's evidence that someone has used drugs intravenously after service, it's going to be hard for them to prove that their hepatitis C exposure began before that in service. An issue with intravenous drug use has to do with 38 C.F.R. section 3.301C3. The use of drugs is not always considered willful misconduct prohibiting an award of VA benefits. Specifically, the regulation provides that organic diseases and disabilities which are a secondary result of the chronic use of drugs and infections coinciding with the injection of drugs will not be considered of willful misconduct origin. So under this regulation, compensation may be available for those with hepatitis C, even if it is the result of drug use during service. The VA is required to make a finding as to whether any reported drug use constitutes willful misconduct under section 3.301. There's been a lot of interest in the issue of whether veterans were infected by jet injectors, also called air gun injectors. I've seen many veterans who served in the 70s and some in the 80s that say that they were, when they entered service, they were lined up in a row with a whole bunch of other veterans, and someone took an air gun and walked down the line and injected each of them without sterilizing it between veterans. And so many people believe that's the source of their hepatitis C. And the VA has recently acknowledged that that is biologically plausible, but they have not acknowledged any actual cases. So it still might be a challenge to service connect based on that, but if there's credible evidence that there's no other risk factors except for that, the VA, I believe, would be willing to acknowledge that as the cause of the infection. Effective dates. So you all know the rule that if a claim is submitted via informal claim or application, that the date of filing of that will establish an effective date. And that can be done, well, informal claims are about to be phased out and replaced with intent to file a claim forms. So that can be used to establish an effective date. starting a claim on e-benefits can also establish an effective date, and the veteran has 1 year to complete the application online. Also, a VA representative can submit a application after speaking with a veteran, say on the VA hotline or at a regional office or any other designated VA representative. But the submittal of those will not establish an effective date where the veteran has not yet developed any, manifested any symptoms of the disability. It's not until there's a manifestation of 10% or more that the veteran will establish an effective date. Also, the date the entitlement to the benefit arose can mean that the date a veteran was eligible for service connection under the regulations. So, for example, say a veteran had a knee injury and filed a claim, but there weren't actually any provisions in the diagnostic codes for compensation for knee injury. But then 6 months after the claim is submitted, the VA does change the regulation, so there is a diagnostic code for knee injury. The date of claim would be the date the regulation was enacted. So there's a number of situations in which there are some special rules for establishing effective dates. Clear and unmistakable error is one, and that's where you might have a claim from 2 decades ago, and the veteran is able to establish that it was based on clear error, and they will get a effective date back to that claim 2 decades ago. When a veteran files and they're within 1 year of discharge, they will get the day after service as their effective date. And then when someone submits a claim for DIC, if it is submitted within 1 year of the death of the veteran, the date of claim will be the first day of the month of the day the veteran died. Similarly, with death pension, if it's submitted within 45 days, same thing. If the veteran died within 45 days, then the effective date will be the first day of the month that the veteran died. Claims for increase. So this is where someone has a worsening condition, and they notice that their condition has noticeably deteriorated. If they submit a claim for increase within 1 year of that deterioration, they should get as an effective date the date of the deterioration. However, this is going to be really hard to prove because most disabilities don't just suddenly become much worse on a single day. It's a gradual process. So proving the deterioration and the date of it is going to be pretty challenging. But a doctor, if you can get a doctor's letter establishing that, that would be a big help. Pension claims, there's on occasion an issue with effective dates with these because if a veteran who is eligible for pension, permanently and totally disabled, but was too incapacitated for 30 days or more to submit a claim, then they'll get the date that the veteran became incapacitated. Discharge upgrades. The decision if a veteran was denied compensation because of, say, having an other than honorable discharge, and then later the veteran gets an upgrade and reapplies, and this time is granted the upgrade, that means that the new claim, basically that shows that the basis for the original denial was the fact of the discharge, that it was OTH. And in that circumstance, the VA assigns the latest of 3 dates. One is the date that the upgrade application was filed. 2 is the date of denial of the VA claim due to discharge. And 3 is 1 year prior to the date the VA received the claim that was granted. So you have the latest of the date the vet applied for the upgrade, the date that the VA denied their claim based on the discharge, or 1 year prior to the VA claim, the new VA claim. Oftentimes that's going to end up being the third. It's going to be 1 year prior to the date the VA received the new claim. Then we have newly obtained military service department records. If the claim is denied and the veteran reapplies later, and the grant of that claim is based on the appearance of a military record that was not considered earlier, the effective date is the date of the original claim. And that service record does not have to be a personnel record, and it does not even have to have the veteran's name attached to it. It could be a record that proves an event that the veteran claimed occurred. So this can be a very powerful way to get an earlier effective date. The document must have existed at the time of the original claim, and this includes a situation where a newly created service record is based on analysis of service records that existed at the time of the claim. So, for example, if the veteran applied for a benefit in 2000 and finds no support for the in-service event and reapplies in 2010, the VA sends a request to the Center for Research of Unit Records, which searches its database for the first time and finds evidence that it furnishes to the VA creates a document that it submits to the VA. Technically, that document is new, but the information is based on existed at the time of the original claim, so that will apply there. Veterans who served on ships that docked in Vietnam may be helped by this rule. If they applied for service connection in the past before the ship was acknowledged by the VA to have stopped at a port, if the ship was not yet, say, on their designated list of ships that have stopped in port during the Vietnam War, and then but then that ship is added, the VA can apply again and probably should receive the initial claim as its effective date. If the veteran did not provide the VA sufficient information to find the service record, the vet does not get the earlier effective date, except when the VA fails to notify the veteran that it needs additional information from the veteran. So this might happen pretty frequently. Veteran doesn't know, maybe doesn't have an advocate, doesn't know what information to submit, doesn't provide enough information about what unit they served in, but the VA never notifies them that they need that information. If the veteran learns later about the rule, they could get an effective and submit the appropriate information, they could get the effective date of the earlier claim. Chapter 35 has to do with when educational benefits based on a veteran who is totally and permanently disabled or who has died, when a dependent or survivor applies, they often apply after it's been established. They won't apply until it's been established that the veteran is totally and permanently disabled, or obviously until the veteran has passed away. And so they won't get the benefit until considerable time after the veteran died or became totally disabled. This basically gives them, applicants, benefits back to the date of the grant of DIC or the date of the grant of acknowledgement of total and permanent disability. From then up until the date of their application, they would get retroactive benefits. And then finally, there's fully developed claims, which I'm sure you're all very familiar with, the program that they have to grant a effective date 1 year prior to submission of a fully developed claim. And this program is going to be in place, or has been, from August 6th, 2013 until August 5th of this year. But it only applies to original claims. It cannot be a claim for increase or a claim to reopen. So those are the special rules related to effective dates. And that is the end of our presentation, of our PowerPoint presentation. So at this time we want to take questions from all of you, and those questions could be about this presentation, anything you had questions about with this presentation, or things that have come up for you at work, or questions related to the OJT program that's been created for you. Or you can share comments as well if you have something, an issue, specific issue of interest that arose with a veteran and you want to share it. Anything like that, we'd be happy to hear from you.
Okay, Katie, we got our first question. And then could you go ahead and leave it on the last slide where it says thank you for your attendance, so everybody has legal's contact information if they need to pick it up as well, Katie? And if you can put that on the full screen.
Yep.
Perfect. And
Sorry
I'll go
about
ahead. Not a problem. I'll go ahead and answer or ask the first question. Our first question is from John Gilbertson. He just wants to know, do we know when the next date for the next training is? Because sometimes they have conflicts of times.
Let's see. I think I have the date, but not the time.
Okay.
The next one is scheduled for February 17th as of now. No, today's February 17th. Never mind that. It's scheduled for March 10th.
March 10th.
March
okay.
10th.
And what will the next topic be?
We don't know exactly, but it's going to be about the next portion of the training manual, probably the next 8 chapters.
Okay. Excellent. And then also from John, they asked for a copy of the PowerPoint slides from this presentation, and I told our attendees that we will go ahead and email that to them at the conclusion of this.
Great.
And it looks like we had a statement from John. It says, I guess the key word to look for in combat distinction is the B in the military device.
Becca, can you answer that?
Was that just a comment that the keyword is the V
Yeah.
in the combat device?
Yes. Is that the key to look for?
Yep, thank you.
Okay, I'm going to give just about another minute to see if anybody else is going to type any questions in. If not, we will get ready to wrap this up.
Okay, please feel free to send us a comment, ask another question. We're here and we want to be able to assist.
Okay, we got one more question in from Michael Sterner. He said something was mentioned about 50% in PTSD being the highest rating possible in certain scenarios. He just asked if you can go over the details of that again. We just missed that portion.
Oh, sorry. If PTSD is diagnosed while you're in service, and I'll get the name of the case to you. I'll have to look up the name of the case unless, Katie, you know it off the top of your head.
I don't.
There was a class action lawsuit that came from the NVLSP that if the veteran was diagnosed with PTSD while in service, the minimum rating they can get for PTSD is 50%. So that's the lowest rating they can get for PTSD.
Great. I'm just going to give about 30 more seconds to see if we have any more questions come through that seem to answer Michael's question, Becca.
Well, I would want to know from you all how the OJT program that we handed out to you is working out, if that's working out okay.
John says, and everybody from Sonoma County says yes.
Good. That's good to hear.
Well then, with that being said, I'm going to let you two go ahead and wrap up this presentation, and thank you two for presenting this information for our attendees.
Okay, just to say that this is the first of 4 webinars that we'll be presenting, and the format should be similar for each one, but with different issues covered. And again, we'll want to hear from you. And as I said, the next one is currently scheduled for March 10th, but there is a chance it's going to change because we have to change the last one, make the last one earlier, so that might affect what dates we want to have the second and third as well. So, but we're going to give you more notice. We didn't get you much notice this time, but for next time you'll definitely get more notice in advance about when it's going to be. And that's it. I hope this has been useful. We look forward to the next one, next webinar, and we'll see you then. Thanks.
Thank you.